Friends, I welcome you all at Swayam platform. We are discussing the course Hindu Personal Law including marriage and succession. Friends, today we will discuss about the dissolution of interest in coparcenary property with a special reference to section 6. But before starting today's lecture, I want to summarize what we discussed in the last class. In the last class, we discussed about the coparcenary, coparceners and joint Hindu family. Friends, we understand that joint Hindu family means not a separate family, which includes lineal male descendant, their wives, widow, mother and unmarried daughter. Joint Hindu family is a broader institution, and as per the law will presume about the existence of joint Hindu family. Friends, after the joint Hindu family, we also discuss about the Karta. Karta as a manager of joint Hindu family, manage the family affairs of joint Hindu family. Friends, we also discuss about the coparcenary. Coparcenary is an institution which exists within the joint Hindu family for the purpose of regulation and management of the property. Coparceners are those who possess the interest and property and the member of coparcenary known as coparcener. Friends, we also discuss about the concept of coparcenary, last holder of the property and next 3 generation. We also discuss the status of coparcener, rights of coparcener, liability of coparcener and disability of coparcener. Coparcener may claim partition, may claim maintenance. The liability of coparcener is they are bound to repay the debt, and disability of coparcener means so long as the property is not divided, they can't sell the property. In the last class, we also discussed a comparative chart, try to identify the differences between joint Hindu family and coparcenary property. Friends, after that, now I want to focus on the today's lecture, where we will focus on the devolution of the interest in coparcenary property with a special reference to section 6. As you are aware about that, section 6 is now amended in the year 2005, therefore it is treated as a revolutionary provision. Friends, before starting anything, I want to discuss and focus on the learning objectives of the today's lecture. Friends, the learning objectives includes first, devolution of interest in a coparcenary property. The learner will able to understand daughter as a part of coparcenary under Hindu Succession Act, daughter's rights after 2005 amendment, natures of daughter's coparcenary property, the pious obligation of son, the status of pious obligation under Hindu Succession Act 1956. These are the learning objectives of today's class, and we will able to understand about these parameters. What is the rule? How Supreme Court interpreted section 6 and what are the status and rights of the daughter after the amendment in section 6 in 2005. Friends, section 6 talks about the devolution of interest in a coparcenary property. After 2005, a very revolutionary provision was made. Now daughter by birth are coparceners in Mitakshara joint Hindu family. This reform has already been made in 4 states: Andhra Pradesh in the year 1986, Tamil Nadu in the year 1989, Maharashtra in the year 1994, Karnataka 1994. They equated son and daughter in their state legislations. Friends, deriving inspirations from the 4 states, the Parliament passed this act it has brought about the fundamental changes in Hindu law. So what are those fundamental changes introduced in Hindu law by 2005 amendment? Friends, it includes change in the composition of Mitakshara coparcenary, change in the law of partition, abolition of the doctrine of pious obligation, and the fourth is change in the law of succession. Friends, why section 6 is relevant? When property is ancestral property, then property will devolve as per section 6. And when the property is self-acquired property, property may devolve as per the intestate succession either of the male or female. Friends, this is the basic difference, friends. In a context of family property, section 6 will apply and property will devolve as per the rule of section 6 of Hindu Succession Act 1956. Friends, the provision of section 6 subclass 1 provides that on and from the commencement of Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitakshara law, the daughter of a coparcener shall first by birth become a coparcener in her own right, the same manner as the son, have the same right in the coparcenary property as she would have had if she had been a son, be subject to the same liability in respect to the said coparcenary property as that of a son, and reference of Hindu Mitakshara coparcenary shall be deemed to include a reference of daughter of a coparcener, provided that nothing contained in this subsection shall affect or invalidate any dissolution or alienation, including any partition or testamentary disposition of property which had taken place before 20th day of December 2004. Friends, this is section 6 subclass 1. Section 6 subclass 1 laid down some fundamental rule, friends. On and from the commencement of this act commenced on 9th September 2005. From on and from the commencement of Hindu Succession Act, daughter of a coparcener have a same status like a son, have a same rights like a son, have a same liability like a son. Means after 2005, for the purpose of law of coparcenary, there is no difference between the son and daughter. But the provision of section 6 subclass 1 shall not affect or invalidate any transaction which has taken place prior to 20 December 2004. This is the section 6 subclass 1 of Hindu Succession Act. Friends, therefore the term from the commencement of Hindu Succession Amendment Act 2005, daughter of a joint Hindu family governed by Mitakshara law are recognized as a coparcener by birth just like a son. Daughter have same legal rights in coparcenary property as son, including the right to demand partition and inherit ancestral property. Along with rights, daughter are also equally liable for any obligation or debt associated with coparcenary property as per the coparcenary. Any legal reference to a coparcener under the Mitakshara law is now deemed to include a daughter, thereby granting her equal legal status in family property matters. The amendment does not affect or invalidate any property disposition, partition or will that was excluded before 20th December 2004. Friends, due to the provision of section 6 subclass 1, a fundamental question emerged in Indian legal system, friends. The law is very clear and simple. On and from the commencement of Hindu Succession Amendment Act, daughter of a coparcener will considered as coparcener. But friends, now a important question emerged before the court, that what will happen if daughter dead before the commencement of this act, or daughter take birth after the commencement of this act? Daughter become the member of coparcenary means coparcenary exists, therefore daughter is now included in coparcenary. Suppose daughter born alive after the death of father, so long as the father not exist, coparcenary cannot exist. Therefore, fundamental question is how we can interpret the terminology on and from the commencement of the Hindu Succession Amendment Act 2005. And the proviso is also clear that nothing in section 6 subclass 1 affect or invalidate any kind of proceeding, any kind of transaction which can taken place prior to 20 December 2004. Now the question is, this amendment is prospective or retrospective, whether it affect the transition after 20 December 2004 or 9/9/2005, or on which date daughter can claim the right, friends. These are some fundamental questions to be examined for the purpose of analysis. Therefore, I want to discuss with you a very prominent Prakash versus Phulvati. The case was decided in 2015 and reported in 2016, friends. Respondent plaintiff filed a case before the additional civil judge for partition and separate possession to the extent of 1/5 share, and argued that late father by inheritance from his adoptive mother. She argued that father received the property from adoptive mother, and from the commencement of this act she is entitled. After the death of her father on 18th February 1988, she acquired the share in the property, and therefore property should be given to her. The counter argument that Phulvati daughter could claim a share only in the self-acquired property of her deceased father, not in the entire coparcenary property. Interestingly, friends, during the pendency of the suit, plaintiff amended the plaint so as to claim a share as per the commencement of 2005. The trial court partly decree 1/28 share in certain property on the basis of notional partition on the death of father, or second, in some of the items of the property no share was given, while 1/7 share was given. Phulvati denied, because during the pendency of suit amendment was taken place. Our decision cannot be based on what is amended by the parliament, because generally it is ruled that the pending case will decide on the basis of law prevalent at the time of cause of action. Therefore, Phulvati filed an appeal in High Court, and she argued that after 2005 amendment she was entitled to inherit the coparcenary property equal to her brother if in reference to other property. And in countering the Phulvati, Prakash argued that Phulvati cannot claim any share in the self-acquired property of member of joint family, and the claim can only be dealt under the section 6 of Hindu Succession Act 1956 as it stood prior to the Amendment Act 2005. The Prakash supplemented and cited a case M. Prithvi Raj versus Nilamma, where the Karnataka High Court decided that if father of plaintiff had died prior to the commencement of the Act 2005, the amended provisions could not apply. It was only the law applicable on the date of opening of succession which was to apply. The question was whether the plaintiff is entitled to a share in the term of section 6 of the Hindu Succession Act 2005 or not. Court held that amendment was applicable to the pending proceeding even if it is taken to be prospective, as High Court decided. Suit was filed in the year 1992. Father dead on 18th February 1988. After 4 years, the partition happened. A legal case was filed in the year 1992. The father coparcener died on this date. A formal partition of joint Hindu property took place around 4 years after the death of father. Argument is notional partition took place on 18th February 1998. Due to the notional partition, property was divided on 18th February 1998. Section 6 of Hindu Succession Act 1956. The question was raised was whether a notional partition occurred automatically on the father's death under the original section 6 of 1956. This is the fundamental point. On and from of the commencement of the amendment word used. This refer to the wording in 2005 amendment to section 6. It is stated that equal rights to daughter apply on and from the commencement date, that is 9 September 2005. Friends, after the hearing by the High Court, Supreme Court finally decided this case. The proviso of section 6 subclass 1 and subsection 5 of section 6 clearly intended to exclude the transition referred to therein which may have taken place prior to 20 December 2004, on which date the bill was introduced. The explanation cannot permit reopening the partition which were valid when effected. Object of giving finality to transition prior to 20th December 2004 is not to make the main provision retrospective in any manner. The object is that by fake transition, available property at the introduction of the bill is not taken away and remained available as and when the right conferred by the statutes. Main provision of the amendment in section 6 subclass 1 and 3 is not in any manner intended to affect but is strengthened in this way. Settled principle governing such transition relied upon by the appellants are not intended to be done away with the period prior to 20th December 2004. In no case statutory notional partition even after 20th December 2004 could be covered by the explanation or the proviso in question. Right under the Amendment Act are applicable to living daughter of living coparcener as on 9th September 2005 irrespective of when such daughter are born. Disposition or alienation includes partition which may have taken place before 20th December 2004 as per law applicable prior to the said date will remain unaffected. Friends, on the basis of the decision of Phulwati case, we are able to understand some fundamental point. The legislature not intended to provide section 6 to retrospective effect. Therefore, on and from the commencement of this act, daughter will be considered as coparcener and have a same status, same right and same liability. The one important question is, friends, for the purpose of coparcenary, daughter may be considered as coparcener when coparcenary exists. Therefore, Supreme Court laid down the rule leaving daughter of living coparcener. Because living coparcener exists, therefore daughter become a coparcener. Suppose in a case if father dead, in absence of father, notional partition took place, there is no coparcenary and therefore daughter cannot claim the right. Therefore, law is very simple and clear. On and from the commencement of this act, Hindu daughter become the member of coparcener. And section 6 will apply only in those cases where living daughter of living coparcener exists. The purpose of giving the date 20 December 2004 have a purpose. The purpose is the property should be available when we are going to implement section 6 of Hindu Marriage Act. Therefore, such kind of provision is there as decided by Phulvati case. Now friends, another case was decided by Honorable Supreme Court Vinita Sharma versus Rakesh Sharma 2020, Supreme Court page number 3713. The Supreme Court held that this case was decided by Justice Arun Mishra and this is very famous case. Now the Supreme Court relaxed the concept of coparcenary and explained the law well. And what Supreme Court concluded is stated in the judgment, particularly in different point. Friends, the provisions contained in substituted section 6 of Hindu Succession Act 1956 confer status of coparcener on the daughter born before or after amendment in the same manner as the son with same rights and liability. The rights can be claimed by the daughter born alive with effect from 9/9/2005 with saving as provided in section 6 of class 1 as to the disposition or alienation, partition or testamentary disposition which had taken place before 20th day of December 2004. Since the right in coparcenary is by birth, it is not necessary that father coparcener should be live as on 9/9/2005. This point where Supreme Court differ with Vinita Sharma in Phulvati case. What Arun Mishra concluded that, he concluded that since coparcenary is by birth, therefore daughter become coparcener by birth, not on and from the commencement of this act. The plain language of this act, daughter become coparcener on and from the commencement of the act. The date is 9 September 2005. But Justice Arun Mishra in this case concluded that since coparcenary is by birth, therefore daughter will be considered as coparcener by birth. Means suppose if daughter born in 1990, daughter considered coparcener from 1990. This is the differential view between the Vinita Sharma and Phulvati case, friends. Friends, certain other provisions was clarified by Supreme Court. The statutory fiction of partition created by proviso to section 6 of Hindu Succession Act 1956 as originally enacted did not bring about the actual partition or disruption of coparcenary. The fiction was only for the purpose of ascertaining the share of deceased coparcener when he was survived by a female heir of the class 1 as specified in the schedule to the Act of 1956 or male relative of such female. The provision of the substituted section 6 are required to be given full effect, notwithstanding that a preliminary decree has been passed. The daughter are to be given share in coparcenary equal to that of a son in pending proceeding for final decree or in appeal. Friends, in order to clarify, Supreme Court said that amendment of 2005 will apply in a case of all pending cases. The case may be in appeal or case may be at any stage. The pending appeal will be decided as per the direction of Supreme Court, means you will treat daughters as a copartner from the date of the birth of daughter. In the view of the provision of the explanation of section 6 subclass 5 of the Act 1956, a plea of oral partition cannot be accepted as the statutory recognized mode of partition effected by a decree of partition duly registered under the provision of Registration Act 1908 are effected by the decree of court. However, in exceptional cases where plea of oral partition is supported by public documents, the partition is fully evinced in the same manner as it is had been effected by the decree of a court. It may be accepted. A plea of partition based on oral evidence alone cannot be accepted and to be rejected outrightly. Friends, further in Vinita Sharma case, Supreme Court concluded that suit appeal are pending before the different high courts and subordinate courts. The matter have already been delayed due to the legal confusion and conflicting decision. The daughter cannot be deprived of their rights of equality conferred upon them by section 6. Hence, we request that the pending matters be decided as far as possible within 6 months. In the view aforesaid discussion and answer, the court overruled view to the contrary expressed in Prakash versus Phulvati, Mangalam versus T.B. Raju. The opinion expressed by Damanna versus Suman is partially overruled to the extent it is contrary to this decision. The Vinita Sharma case adopted very liberal and lenient view, means daughter become copartner from the date of birth, not from the commencement of this act. This is also further clear that this provision, amending provision, will also apply in pending cases, cases in appeal or any stage, and on that basis decision will be taken, friends. And therefore, friends, some critique argued that this decision is the fundamental notion of the idea of coparcenary, friends. Now I want to discuss section 6 subclass 2, nature of the daughter's coparcenary property. Section 6 subclass 2. Any property to which a female Hindu becomes entitled by virtue of subsection 1 shall be held by her with the incident of coparcenary ownership and shall be regarded, notwithstanding anything contained in this act or any other law, for the time being in force, as property capable of being disposed of by her by testamentary disposition. This provision is clarifying provisions, and the provisions clarify that daughter takes right in the joint Hindu family property subject to the incidents of a coparcenary property. The property is also capable of being disposed by her as per bill. Section 30 of Hindu Succession Act 1956 is also amended to authorize the daughter to make a testamentary disposition of her property. So, what kind of property received by daughter will be treated as the absolute property of her? The property is capable for disposition of intestate and testamentary succession both. Means what received by daughter under section 6 be considered the absolute property of a daughter. Friends, now I want to focus on section 6 subclass 3, where a Hindu dies after the commencement of Hindu Succession Amendment Act 2005. His interest in the property of joint Hindu family governed by Mitakshara law shall devolve by testamentary or intestate succession, as the case may be under this act, not by survivalship, and the coparcenary property shall be deemed to have been divided as if a partition had taken place. The daughter is allotted to the same share as is allotted to a son. the share of predeceased son and predeceased daughter, as they would have got had even been alive at the time of partition, shall be allotted to the surviving child of such predeceased son or of such predeceased daughter, and the share of predeceased child of a predeceased son or of a predeceased daughter as such child would have got had he or she been alive at the time of the partition, shall be allotted to the child of such predeceased child of a predeceased son or predeceased daughter as the case may be. How the property will devolve? Friends, doctrine of survivalship was abolished under section 6 subclass 3, and section 6 subclass 3 laid down the list. In a circumstances where the property is coparcenary property, how the property will devolve. And daughter will acquire one share of the property and son, predeceased son, will acquire one property. This is the rule of section 6 subclass 3. The consequence of section 6 subclass 3 is abolition of survivalship. Under the Shastric Hindu law, the interest of a coparcener in Mitakshara coparcenary property did not devolve by succession on his heir but by survivalship on the surviving coparcener. Hindu Women's Right to Property Act 1937, repealed by Hindu Succession Act 1956, allowed coparceners' widow rights to claim partition in coparcenary property. Hindu Succession Act 1956 provide that if the deceased coparcener was survived by any of the 9 heirs, his interest was to devolve by succession, not by survivalship. After amendment 2005, interest of a coparcener in the joint family property devolve on his death by testamentary or intestate succession under the Hindu Succession Act, not by survivalship. This is the point, friends. So after 6 subclass 3 as amended, there is no rule of survivalship. Property will devolve as per the section 6 subclass 3 as mentioned. Friends, the idea of notional partition is also relevant under section 6 subclass 3. A case Gurpat versus Hari Bhai, Supreme Court observed that the fiction created by section 6 subclass 3 has to be given its due and full effect. Once the assumption is made that there was partition immediately before the death of the deceased, it must permit all the consequences which flow from a real partition have to be logically worked out. Partition is that the her will get his or her share in the interest which the deceased had in coparcenary property at the time of his death, in addition of the share which the proportion of the share of the deceased coparcener on the notional or deemed partition will be calculated in accordance with the rule of partition. He or she received or must be deemed to have received in a notional partition. Friends, the coparcener whose interest in the coparcenary property is to devolve by succession dies united with the joint family. The share of any coparcener cannot be known unless it is separated from the joint Hindu family. Therefore, Hindu Succession Act 1956 here resort to legal fiction that immediately before the death of the deceased coparcener, partition of joint property took place and the share which would have been allotted to him and would be continued as his interest. By notional partition, the share of coparcener are crystallized, therefore partition cannot be alienated by any member of the family. Friends, fundamental question is, what do you mean by notional partition? Notional partition means not a real partition. Notional partition means law will presume that at the time of death of a deceased person, property is divided and vested in relevant people. Because so long as the property is not divided, you cannot claim the right, you cannot sell the property. Therefore, notional partition took place, it was presumed by the law, and property will devolve to the actual heirs of the property. Friends, now section 6 subclass 4. After the commencement of Hindu Succession Amendment Act, no court shall recognize any right to proceed against the son, grandson, great-grandson for the recovery of any debt due to his father, grandfather and great-grandfather solely on the ground of pious obligation under the Hindu law of such son, grandson, great-grandson to discharge any such debt, provided that in a case of any debt contracted before the commencement of Hindu Succession Amendment Act 2005, nothing contained in this subsection shall affect, or the right of any creditor to proceed against the son, grandson, great-grandson, as the case may be any alienation made in respect of or in satisfaction of any such debt, and any such rights or alienation shall be enforceable under the rule of pious obligation of the same manner and the same extent as it would have been enforceable as if the Hindu Succession Act 2005 had not been enacted. Now the friends, law is very simple and clear. Doctrine of pious obligation means as a son, grandson, great-grandson, you are liable to repay the debt taken by father, grandfather, great-grandfather. This is pious obligation, friends. And it is your legal duty to repay the debt. We should also examine, friends, person liable to repay the debt. Borrower, every borrower is under the obligations to repay the debt if they taken it from personal purposes. Coparcenary, if a debt is incurred by a karta in joint Hindu family for a legal necessity, the benefit to the family estate, then all coparceners are liable to repay the debt. The obligation is, however, not personal, it is limited to their interest in the coparcenary property. Heirs, the heirs of successor of the deceased who get his property by succession come under the obligation to repay the debt. The obligation extends only to the property of successor get by succession. Friends, this is the pious obligation. It is enacted from a son that he would relieve his father from both debt, worldly and spiritual, so that father may be saved from the post-mortal suffering. The foundation of this obligation is not in the benefit of creditor, but to the benefit of father. If the son, grandson, great-grandson has obtained interest in the paternal property, then they are liable to discharge the debt respectively of their father, grandfather and great-grandfather. If they have not got the paternal property, the son is bound to repay the debt of his father with interest. Grandson to repay the debt of his grandfather without debt, and if not interested to repay, then need not to pay even capital amount. The obligation generally arises on the death of debitor's fathers, but in certain circumstances it arises during his lifetime when the father goes away foreign country suffering from incurable disease and becomes too old. In these circumstances, during the lifetime of the father, son will repay the debt, friends. Hindu Heirs Relief Act 1986, nobody could sue a Hindu son, grandson for the payment of the debt of his father, grandfather, great-grandfather on the basis of relationship. They are liable to discharge the debt of that person only to the extent of property he has inherited from him. Friends, Caste Disability Removal Act 1950, where the convertee son takes his interest in joint Hindu family property by force of the act, they are bound to repay the debt. Pious obligation of son exists in the reference of father, grandfather, great grandfather. There is no pious obligation of a father towards his son or towards his mother or spouse. Now, friends, I want to discuss the period of limitation. No period of limitation under Shastric law for the repayment. Indian Limitation Act 1963. 12-year is now provided, and as per section 62, for a debt secured by mortgage, 3 years of unsecured debt, article 19, 20, 21 and 23. The limitation period is there and you are bound to claim the rights within the limitation period, friends. Now section 6 subclass 5, nothing contained in this section shall apply to a partition which had been effected before the 28th day of December 2004. It shall not apply in a case of partition before 20 December 2004. It shapes early partition which took place before 20 December 2004. Friends, now on the basis of the discussion, you can think about certain point. What is the scope of daughter's liability in relation to the coparcenary property? Can a daughter claim coparcenary rights if her father passed away before 2005 amendment, but no partition had taken place? Friends, before closing my discussion, I want to clarify certain point. What is section 6 subclass 1? Section 6 subclass 1 tell us that on and from the commencement of Hindu Succession Amendment Act, daughter of a coparcener also considered as coparcener and have same status, same rights and same liability like a son. Section 6 subclass 1 is right conferring provision. But now the question is, from which date daughter become coparcener? On and from the commencement, that is 9 September 2005, or prior to that? In Phulvati case, Supreme Court concluded that daughter become coparcener on 9 September 2005 and therefore there must be living daughter of living coparcener. But in Vinita Sharma case, Justice Arun Mishra concluded that no, coparcenary is by birth, therefore daughter is coparcener by birth and therefore she can claim right after this. So this is the fundamental different interpretation of the law, friends. Friends, now we also discuss about the section 6 subclass 2, where we discuss the nature of the property inherited by a daughter under section 6 subclass 1. The property is still considered as absolute, and this is the clarifying provisions which declare that daughter's property not become paternal property, daughter become the property of independent. Friends, so we also discussed the section 6 subclass 3, where we discuss the evolution of survivalship, how the property will be devolved from one person to another person. Different kind of relatives were there. Property will devolve to them. But friends, the fundamental right is doctrine of notional partition. Notional partition means there is no real partition but law presuming the partition. The idea of notional partition is discussed in the case because on the death, generally we think that it's the case of notional partition. So these are the discussions. On that basis, we are able to understand the devolution of property within the coparcenary as per section 6. Be careful, friends. Section 6 applied only case where the property is paternal, not a self-acquired property. Therefore, now daughter become coparcener from the date of birth. There is no need of leaving father at the time of enforcement. These are some fundamental points. Thank you for your patience. Thank you.